All right, everyone, we start off today with rather big news. The Supreme Court is indeed going to take up the case sparked in Colorado over Trump's ballot access. Of course, the Colorado Supreme Court ruled on completely partisan grounds that he was no longer eligible to be on the primary ballot there because he engaged in insurrection. They invoked the Insurrection Act on Article 3. The problem being he was never actually found to have done that. And the Colorado case, they just basically decided it out of thin air without an actual criminal trial. See, the problem is that committing something like sedition, it would require a criminal trial. It's out of the hands, it appears, of the states to actually do it. This would be a federal matter. What I suspect is that the Supreme Court is going to rule in Trump's favor. It may or may not be a split decision. Someone like Ketanji, of course, they're going to want to rule in favor of the Colorado State Supreme Court's decision. But will they be able to find even one shred of legal doctrine to back up that position, again, for partisan reasons? A state Supreme Court may be hyper-partisan. The federal Supreme Court, the actual Supreme Court of the United States, typically attempts to avoid such things. There's definitely some partisan crap that goes on there, but on really important decisions, they tend to be more restrained. So it might be a 9-0 decision, which, by the way, if that happens, the liberals are really going to have a hard time, because they're going to have to explain how Ketanji and others ruled in his favor, and therefore their arguments are legally meaningless and vacuous. They'll have to explain to their constituents why that happened, because the leftoids aren't going to like it. I suspect that they'll rule narrowly in his favor, and the way to do that is this. Simply assert the fact that this is a federal matter, so the state Supreme Court's original gathering, the little assembly that they got together to decree that Donald Trump committed insurrection, is legally meaningless. And they say, well, whether or not he did, there hasn't been an actual federal case against him on these charges. He's never been found guilty. He was acquitted by the Senate in the impeachment proceedings, which, I mean, had he been actually removed from office, I guess you could kind of sort of invoke Article 3. Still, because it's not a properly incepted court of law, again, it's not necessarily, even legally meaningful. And they'll rule also that they'll simply rule on that grounds, I think. A more expansive ruling would be that they side with certain legal scholars and say the Insurrection Act doesn't mean anything anymore because the Civil War was too long ago. This was a radical Reconstruction period sort of addendum. It doesn't have any modern relevance. I suspect they would be reluctant to do so, though. And actually, I would agree with the assertion that Article 3 is still something that's in legal force. And the reason why is this. Otherwise, public officials, and not just the President of the United States, could commit crimes and then simply claim immunity, no matter what the crimes were. So you could have an egregious crime. A former president or vice president or something flips their lid, and they go psycho when they leave office and they kill somebody. And you've got it on tape, like you've got them dead to rights legally, but then all of a sudden you can't prosecute them or prevent them from holding further office. That would be a little bit of a problem. That would be the most expansive possible definition that they could give. I would say that the best thing to do is simply proclaim that in this particular singular instance, irrespective of the applicability of the insurrection clause, that it doesn't apply to Trump because he wasn't found guilty of the same, and that an informal sort of legal proceeding at the state level can't supersede that federal doctrine and simply assert that that's a federal issue. So if the federal government were to put you before the judge, sue you in court, say you committed insurrection and you were found guilty of insurrection, then it would apply. But it doesn't apply if there's no actual legal proceeding against you. Again, if you've got the evidence that Donald Trump attempted to overthrow the government, well then prosecute him and find him guilty. And there are plenty of courts out there that would be most amenable to doing so, by the way, because of their partisan structure. He's already going before 4 different courts at the same time. You got the fraud cases, you've got Fulton's RICO cases, Letitia James, who just upgraded the amount of money and damages that she wants from Trump and his organization to about $350 million, if I remember correctly. Seems a little onerous, despite the fact that there is literally no aggrieved plaintiff in those cases, by the way. Not a bank, not a developer, not an investor. They were all happy. It's just literally Letitia James having a hissy fit. And then you've got, of course, the Mar-a-Lago documents cases. There are plenty of courts out there would be willing to file spurious charges of insurrection against Donald Trump. But they don't have the legal standing to do so, and they know that the case would fall through because it's meritless. Because there was never an insurrection on J6 anyway. I mean, here we are on J6. Happy anniversary. It's Ashley Babbitt Day, by the way. And SCOTUS finally agreeing to take up this case. I suspect they'll expedite it. I guess in mid-February is when they're hearing oral arguments. It probably won't take them very long to reach a decision. Because, I mean, you sort of have to expedite it because the attempt is being made by Colorado and now by Maine, and other states are attempting this too, to literally interfere with the election. And it's not even the general, where, by the way, this would be more applicable. Where exactly in Article 3 does it state that a political party cannot nominate whoever they want and they would simply be barred from the general election? Because the parties, while they operate under certain terms of election law, have wide latitude to do pretty much everything they want. For example, let's say that I hold an informal primary here in the state of Vermont for the Clanker Party or something. And we find an insurrectionist in Vermont and we say, okay, well, we're nominating you for mayor. If they're an insurrectionist, then the act would come into focus, assuming that SCOTUS rules that it's applicable at all in the wake of the Reconstruction period, and they could keep them off the general ballot. But can they prevent me from holding a primary and simply deeming that to be the candidate of the Clanker Party? It doesn't appear, legally speaking, that they can, because it's just a primary. It doesn't put them into political office. Ineligibility, by the way, for a political office would not nullify the ability of a party to nominate a person anyway. These are the primaries that we're talking about. This is not the general election that's being referred to in these cases. I mean, it carries over. If SCOTUS were to side against Trump, necessarily, of course, they'd be saying that he is scored off the general election ballot again. At some point, you've got to start printing the ballots. I would think that SCOTUS needs to decide this fairly quickly. In fact, I think they should have moved it to the head of the docket and begun discussing it right away. I guess they have no choice but to give time for both sides to prepare legal paperwork and prep their arguments and stuff like that. But, you know, the clock is ticking. Iowa's only a week away, so, you know, get on it. SCOTUS tends to be rather slow sometimes, but I would think this was a transcendently important case specifically because of the wide-reaching ramifications. Effectively, if SCOTUS sides against Trump, to be clear about how damaging this would be to our democracy, in the literal sense, our republic, to prove how damaging it would be, you would effectively be giving the right to any state Supreme Court, or potentially Secretary of State, according to the main precedent that they're trying to set, to prevent anyone that they should choose from being on the ballot simply by claiming to self-profess that the person was guilty of insurrection, without any legal case whatsoever. No finding of guilt in an actual court of law at the federal or at the state level, because he hasn't been found guilty. If he were, he'd literally be in prison. It would be more than a fining offense. But again, the Supreme Court of necessity, assuming that it follows doctrine and canon within the law whatsoever, should find 9-0 in Trump's favor. I expect a likelihood, though, that it'll be a split decision, a 6-3 or something like that. If it is 9-0, though, the Trump stacked the Supreme Court, we must stop him argument will die. And that would be about the worst thing possible, by the way, right now for the Democrats to suffer. If Trump does prevail 9-0, they are fucked. That's about all. Peace out.